Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas, as well as in federal courts nationwide. I'm Lisa Mosby, your host, and today we're discussing indemnity contribution and risk allocation in Texas commercial lawsuits. Welcome back, Bob. Thanks for joining me.
Oh, thank you.
You know, Bob, in complex commercial litigation, how do indemnity and contribution issues typically arise once multiple parties are involved?
Indemnity is, generally speaking, a matter of contracts. There are relatively few common law rights of indemnity or indemnification. Now, indemnification means party A has to completely hold harmless party B. In other words, they're 100% responsible to party B. So in contracts, commercial contracts, oftentimes one party agrees to indemnify the other, and it can become complicated if the party that owes the indemnity is not already a party. Then they may or may not be, depending on who the plaintiff is sued. But the dynamic then is you have to make a demand on the person that's supposed to provide the indemnity. They have they're supposed to pick up the defense. In other words, they're supposed to hire the lawyer and pay for the lawyer and handle the defense. A lot of times they don't. They acknowledge receipt of the demand for indemnification and providing a defense, but then just sort of wait to see what happens with the litigation. That's sort of from the party who's supposed to be indemnified. That's an imperfect resolution of what they thought they were getting from the contract. So there may be satellite litigation. There may be another case if the indemnifying party is not already a party to the lawsuit. There may be a separate lawsuit by the party who is supposed to be indemnified to try and force the indemnification, so they don't have to slog through the case and pay all the fees, and hopefully get reimbursed at the end. Contribution is a little more. A contribution is, generally speaking, a common law theory, and it is, it's based on your percentage of responsibility, if you will. So you can bring in, for example, if you're a defendant, you can bring in as a third-party defendant somebody that you claim is liable either to you or to the plaintiff for all or a portion of the plaintiff's damages. And then the plaintiff then would have the option to do what's called plead over against that person. In other words, join them as a defendant. One of the things about Texas state court practice is it's more flexible in terms of amending your pleadings and joining additional parties than federal court is. Federal court generally you have to move and obtain leave from the court to do that. So, that's, and that happens a lot in construction cases, for example. Say there's construction defect problems, the owner sues the general contractor and the architect and the engineer, and, those people, turn around and say, well, hey, say it's a foundation problem. The structural engineer may say, well, look, my design was fine. It was the concrete guy that screwed up and has defective construction. So they third party that person in, and then the owner may be able to plead over against that person. But it brings the people in so that at the end of the day, when you go to the jury, there is what's called the allocation question. So it's were these people negligent, for example, and then there's a list with blanks next to each name for the jury to fill in percentages. and it's supposed to add up to 100%. And so the plaintiff could be on there, the main defendant, the third-party defendant, and then in Texas, we have what's called a responsible third-party practice, where you don't join the person as a party to the lawsuit, but you designate them as a responsible third party, and then you get their name in a blank on the verdict form.
So, when drafting commercial agreements, how often do indemnity provisions become central once litigation begins?
Well, I mean, they become important, like, right at the outset. When somebody gets sued, uh, you don't wanna uh, sit on your rights and have the lawsuit go on for a while. I mean, in some circumstances, it's almost like an insurance company. There's an obligation to provide prompt notice of a claim. Uh, so, the indemnifying party can take steps to see that the lawsuit is properly defended. Um, but and then there's you know issues of whether everybody's already in the lawsuit or not. So people may need to be brought in. There may need to be satellite litigation, but uh, if it's a big dollar lawsuit, the question of indemnification is a very important question, and you know central to how the case gets resolved.
And you've talked about multiple parties. So, in multiple party disputes involving contractors, lenders, insurers, joint ventures, how does the allocation of responsibility affect the overall litigation strategy?
Okay, I guess from the plaintiff's perspective, see, in Texas, we've got a proportionate responsibility scheme, if you will. Um, and so if the plaintiff is more than 50% at fault, the plaintiff recovers nothing. Um, so for the plaintiff, it's beneficial to have more lines on the blank because there's more defendants and third parties to have uh, percentages allocated to, which tends to make it less likely that the plaintiff is going to get tagged for 50+ percent of the responsibility. Um, from the defense side, uh, again, in Texas, generally speaking, unless you get above 50%, your what can be collected from you is limited to your percentage times the damages. So in other words, if you're only 10% at fault, the jury finds that you're only 10% at fault. Um, the plaintiff can only recover 10% of their damages from you.
I'm tracking with that. Exactly. So, how do courts approach competing indemnity claims when multiple agreements intersect in a single dispute?
I suppose it can come up on cross motions for summary judgment. Each side files a summary judgment motion saying, I'm owed indemnity from X, and X files a motion saying, I don't owe them any indemnification. Um, but yeah, it can become complex, and I think state court judges typically don't relish having to wade into those sort of uh, quagmires.
Okay. So, from a trial perspective, how do allocation questions influence how a case is presented to a jury?
Well, it's like I said, if it's if you're under the proportionate responsibility or comparative fault, uh, and you're a defendant, you want to get 50% or more on the plaintiff, and you want to have your own percentage as small as possible. So, in that circumstance, uh, if you think you don't really have a good shot at getting the plaintiff more than 50%, then having additional blanks, so bringing in responsible third parties, or having them designated. You're not really bringing them in, but they're not a party. They don't get to present argument or evidence or anything like that. But their name is on the verdict form, and there's a blank, and they get assigned a percentage of responsibility. If your goal is to um, keep your percentage as low as possible, then having responsible third parties and third party defendants, other folks in there to have fault allocated to is beneficial to you. Uh, I guess in terms of jury presentation, there's also the issue that the responsible third party is an empty chair. You're blaming somebody who's not there, and while they're not there to fight back, you have to be cognizant of how the jury is perceiving that, whether they're perceiving that you're you know basically fighting with a ghost, and tend to discount your presentation because of perceived unfairness.
I can see how that would be tricky. Yeah, nobody wants to blame an empty chair. They want to find a responsible party. That makes sense. Bob, with insurance coverage, often it overlaps with indemnity obligations. How does the presence of insurance layer change the dynamic between defendants, or does it?
Well, I mean, it can. If particularly if you've got a defendant that is, maybe not necessarily judgment proof, but not really able to respond to a big damage number, um, and another defendant who has more insurance, they may, you know, sort of allow the other defendant to kind of piggyback on what they're doing. Um, so because it's not, for example, um, in the Americans with Disability Act and Fair Housing Act cases where it's apartment project is built, it violates the accessibility guidelines. So somebody, a person with disabilities, sues, and they typically sue the general contractor, the owner, and sometimes the architect. Well, from the owner's perspective, they're going to own it whether it was a construction defect or a design defect. In other words, if the architect designed it correctly to comply with the accessibility standards, but the contractor or their subs didn't build it right, that's still the owner's responsibility to fix it, to pay to have it corrected. And so they have an interest in having the general contractor be able to defend what was done. All right. So they very well may allow the general contractor use their same experts to kind of, like I said, piggyback on their efforts, particularly if they've got um, you know either they're financially able to respond to a big judgment, or they've got insurance that could do it. And then the insurance companies have typically on big dollar cases, they have claims attorneys who are monitoring the cases and conferring with defense counsel, uh, not necessarily making the calls, but you know, providing their input into some of the decision making that's going on in terms of how the case gets prosecuted.
Where I want to wrap up today is for corporate decision makers facing a multi party commercial dispute, what considerations should guide how they assess allocation risk early in the case?
So, well, that I mean, that requires an analysis of all the players and potential pockets that the defendant or that the plaintiff could be trying to reach into, and what are the respective rights as between or among them. So it requires an analysis of all those factors. You're going to have to try and figure out pretty early on. Does it make sense to make an indemnification demand, or is this a case where you think you can beat it, so maybe you don't bother with it? Uh, a lot of times the prospect of ongoing business between an indemnified party and a party who's providing the indemnity can factor into the decision about how hard to push the indemnification demand or whether to provide it or not. So, those business considerations come into play as well.
And that's where we'll leave it for today. Thank you so much for your insights. Folks, that's it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Bob and his firm's work in business and intellectual property litigation, visit carterarnett.com. Thank you so much for listening, and remember to like, subscribe, and share this episode with someone who might need it today. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.